is the meeting of the House Judiciary Committee. We've got 1, 2, 3, 4, 5, 6 Senate matters before us. And the first one I'm going to take a little out of order, but it'll be Senate Bill 275, which I believe, Senator Williams, you come up, please, and we'll hear your bill first. Senate Bill 275 LC 28 8058S. Let me get your mic on there. Sorry. Go ahead. Thank you, sir.
Thank you, Mr. Chairman, members of the committee. Basically, what this bill does is it ensures that members of the Board of Education have the ability to discuss freely any policies that the board might take or have taken without any fear of being gagged or restrained. That's it.
And what causes that? What brings about the need for the bill? Let's hear it.
Oh, the state code of ethics has a policy that states once a board position has been voted on, that board members are not allowed to speak out against it, and that needs to be changed.
And I read that, and I was really a little amazed, miffed that the board has something like that in their policy.
Yes, sir.
For officials. Has anyone addressed them as to the impropriety of having this lockdown on freedom of speech?
I personally,
ethics.
Yeah, I personally have not addressed them about it, but I know in carrying this bill through both the Senate and through subcommittee of the House, I've heard several stories of where this type of behavior has been occurring, and I would believe that it has been discussed before, but not to my knowledge.
And do I understand that not only they have it in their ethics, but they also have it where the members of the state board have to sign, I'll call it a pledge or whatever,
correct,
that they will abide by all of these ethics standards.
That is
so if
correct.
they violate it, what would that do as far as triggering?
It would trigger
action?
an ethics violation.
Okay. Is anyone here from the state school board? Have they not appeared at any meetings about this?
They did at our subcommittee meeting here in the House, and they spoke out against the original bill. They said it was too broad and it wasn't limited to just the board. So the subcommittee did a great job of rewording it to make it more defined in what we're trying to accomplish. And after the amendment was made, or the substitute was made, the School Board Association was fine with it.
All right, and this only applies to, you say, local school boards. Does it not apply to also the state school board?
Just the local Board of Education.
And who promulgates this rule that's used for the ethics standards?
When you say who promulgates it,
who makes them up? Who prepares this and says this
the
is what
the school
we've
board,
adopted?
the ethics?
These ethics standards that you talked about?
This was the Georgia State Board of Education.
Well, that's what I'm asking about. So State Board of Education has a hand in this?
Yes.
And no one has come forward and said, we realize this may not be the proper thing to do.
Not to me personally, no, sir.
All right. Well, thank you, Senator Williams. Any questions by members of the committee of the presenter? We thank you. Is there anyone else who would like to address the committee on Senate Bill 275? There being none, the chair will close off further public comment, and the bill is now in the breast of the committee. Chair will accept motion. Motions do pass and second it. Is there any discussion on the motion? Is there any proposed amendments? You have discussion. Yes, sir. Please come forward.
Thank you, Mr. Chairman. This bill did come through subcommittee, as the senator mentioned, and Representative Evans and I worked on the bill that you have in front of you. It was very broad. That brought in a lot of other local government entities when I thought we were just focused on the school board issue. And I identify what the senator's talking about. I have in the past tried to talk to my school board members about certain reasons why they don't respond to citizens when they have questions and whatnot. And they always made this vague reference to the fact that they couldn't. And I never fully understood it, and I think I understand it better now. But I don't think we should have any state board in Georgia that can't properly talk with citizens about the issues that they have. And I appreciate you bringing the bill. And I thank Representative Evans for helping me work on the substitute.
And again, I reiterate, I'm just surprised the state board hasn't come forward and say, you know, that may be beyond what we're asking or should be asking board members to do, and remove that from their ethics standards. It's just
It's
ridiculous.
crazy, yeah.
Ridiculous. Any further discussion? No amendments. The chair will call the main question, which is due pass Senate Bill 275 LC 288058S as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. And you have another bill?
Yes, sir.
That's Senate Bill 356.
Yes, sir.
And we'll take 356 so you can
Okay.
move on to your next committee.
All right. Well, thank you. Thank you, Mr. Chairman.
Let me just state, this is LC 297092S, that's Senate Bill 356.
Yes, sir.
Thank you.
Yes,
Senator
sir.
Williams. Oh, yes.
Oh.
On your first bill,
On the
who will be?
275, it's going to be Representative Dudgeon, Mike Dudgeon.
Mike Dudgeon, all right.
Yes, sir.
Former school board member, that's good.
Yes, sir.
And on your Senate Bill 356,
It's Golick, Representative Golick.
thank you. Proceed.
Okay. All right, SB 356, basically it establishes a legal process so that anyone who has had his or her animal lawfully seized due to criminal activity may be required to pay for the animal's care. Also, it helps local and state agencies in Georgia from incurring huge costs in animal cruelty cases, thus saving taxpayer dollars, and also in some instances, animals' lives. As we talked about yesterday, there's already 34 states that have this as law. Washington is in the process of making it law as well. ACCG, the prosecuting attorneys, the Georgia Sheriff's Association, they all support this bill. And again, it just puts the onus of caring for animals whenever they've been impounded due to criminal activity on the owner. And if you have any questions, be glad to answer them.
All right. We have any questions of the presenter? Seem to give a full explanation. Mr. Spejos, you want to add to the comments?
Thank you, Mr. Chairman. I'm simply here to answer any questions. This is a cleanup bill that makes clear that this process would apply to not only the Department of Agriculture but also to any law enforcement officers that impound animals under the cruelty to animal statute or the dog fighting statute. I could go through it. I know we did that at subcommittee, line by line, or I can just answer any questions. This is a good due process type bill that would allow the court to intervene earlier in the process to make a determination as to whether or not the individual truly intends to keep the animal at the end of this, and if so, are they willing to pay for the upkeep of that animal, or if they're going to relinquish it, which is what they do a majority of the time, then go ahead and relinquish it and don't have the county or the municipality, stuck on the bill for an extended period of time.
Thank you, sir. Mr. Fleming.
Thank you, Mr. Chairman. I was just going to address something that you mentioned to me. I know that early on in this process, there was some concern about the definition of owner in this bill. And that definition was changed in subcommittee to include some language to make sure that we didn't bring into this people who were temporarily in custody of a pet. You want to comment on that?
I do. I'll be honest with you. I didn't get to see that language ahead of time at subcommittee. It did go in. I've had some conversation with council today. I haven't had any conversation with the senator. So there is a little bit of concern about what got added. Let me say this: the definition that was in the version that would come to subcommittee of owner is the definition that came straight out of our cruelty to animal statute 1612.4, which we all worked diligently on several years ago when we rewrote our animal law. So we think it is a good definition of owner that requires that intentional exercising of control, so that it doesn't cover the example of somebody that just started feeding a stray cat or a stray dog because they felt sorry for the animal. They had to intentionally exercise control. The language that got added yesterday, and the senator didn't get to see it ahead of time either, attempts to carve out for retail establishments that temporarily harbor an animal on its owned or leased premises for the purposes of performing a service for compensation regarding any such animal. The concern that was raised earlier today, and I'll have to admit that I acknowledge that there may be some issue with that, is that's a very broad exception. It would allow an individual to hold themselves out as a retail establishment to wash dogs or take care of horses or what have you, and then also be abusing animals on the same premises or not tending to them or dog fighting for that matter. And that, as broadly as this is written, it may prevent this process of seeking care for those animals not to apply to them. I don't know that that was the subcommittee's intent, and Legislative Council may or may not agree with me. I know there was we were having conversation through another lawyer.
May or may not. Right?
Yeah.
So true.
So
Thank you, sir.
it would be my opinion we probably should consider reverting back to
Yes.
the subcommittee's original.
We're going to look at your definition under cruel treatment, I think. Try to follow the same standard.
And I believe that the version that came to subcommittee is also contained in the committee's folder
right.
if they choose, if the committee so chooses just to move forward on that original version.
Thank you. Mr. Fleming, anything further?
That was the only change in subcommittee, wasn't it?
Okay.
Was that the only change in subcommittee? That
Yes, yes, it was.
it was? Okay, yeah.
Okay. Ms. Evans, is that yours? Oh, sorry, Ms.
Thank you.
Jones.
Mr. Chairman, thank you. So is there, I'll give you all my questions so you can answer once. Is there a way to determine the cost of impounding? Because it looks like you're going to kind of impose this cost at the beginning of the process. And so I've had a couple of animal cruelty cases, and here this person is accused of a crime, not convicted, not pled guilty right now. They're having to hire an attorney. They've lost their animal, and now they have to put this money into the registry of the court. I see that there is a process for indigence that they can apply for, but as we've seen many times in court, someone may not be indigent enough to qualify, but not rich enough to be able to pay for all of these costs. And so my concern is people not receiving due process because they cannot afford the cost to pay to the state to maintain these animals until such time they're found innocent, who, depending on where you are, could take years.
Correct. What I would point you to is during in section 6 where we lay out the process. You have the court do two findings. So first of all, it's not just that the animals were seized, but that there was probable cause for seizing the animals. So what we've done is we've imposed a criminal concept in this civil proceeding. So we don't want anybody's animals seized and they be responsible for these expenses unless there's at least probable cause that those animals were involved in either cruelty to animal cases or dogfighting cases. So that's the first thing the court's got to find before they can do anything else. The next thing it leaves, and I'll quote, the as determined by the court is the amount of money to be imposed upon this owner. So it is given complete judicial discretion. I'm certain that the county or city that's seized would be required to make some sort of showing of what those expenses are, and the court could take all or none or part of those expenses depending on what the court determined appropriate. So I think there's a lot of judicial leeway in this process.
Has it been passed out?
Thank you.
Where's this one? All right. Well, we finding out something new here. I didn't realize there's another bill in here that is a further substitute.
It's the earlier version.
The first version. Let's see. Made aware of that. Here we go. Here we go. If you look in your folder, I think the last document you have is SB 356 FA1. Does everyone have that in their folder? And what you have is a different definition. You have a definition I'll read out to everyone. 5.1. Owner means a person who intentionally exercises custody, control, possession, or ownership of an animal, period.
Yes, sir. That's straight out of the Cruelty to Animal Statute 1612.
That's what I wanted to do. So that is now, we will, at the chair's direction, be working with SB 356 FA1. Okay. Anything further, Ms. Jones?
Yes.
Any other questions of the presenters? Do we have anyone else who would like to address the committee on SB 356? Yes, sir. We're going to let them come forward. One of you all stand up. We'll let him take a seat here, please.
Real quick, and I don't want to take any.
No problem. Give us your name and if you represent a group, that group's name.
Hi, my name's Eden Davis. I'm representing the Georgia Retail Association today. We were the organization that brought some concerns with the initial language that was brought, and now it's been has been added again. Our concern is several of our member companies engage in, dog grooming, those kind of services performed for compensation. And our concern today is that under that definition, we would be considered an owner, and in this kind of hypothetical that there would be some point to where one of our associates finds a dog that's been mistreated, turns it into a local animal control, and then somehow we would be considered the owner if we couldn't prove who the owner of the animal was or something like that, to where they would be coming back to our retail establishment looking for the care and for the dollars to be able to protect those animals. That's kind of our concern, and we wanted to be clear that a retail establishment wouldn't be an owner of an animal at any point.
I don't think the definition would broaden it to what you talked about.
Okay.
It's really, because you're not exercising continuing control, custody, or possession of the animal. If you had an animal that was brought to you in a condition that needs care, you take it, may do what you need to as far as immediate care, but you're going to turn it over to, I guess, whatever animal shelter covers that jurisdiction, are you not?
We would turn it over, and we do that several times.
Right.
And our concern is that when the counties or cities are looking for who to find relief for those dollars spent on that animal, we would be, under that definition, be in possession of that animal.
I don't think a court would look at it that way. I can't imagine
Okay.
the wisdom of some judge saying, well, let's try and just hook somebody with a bill.
Okay, we worked on, this organization worked on, in Tennessee, a similar statute and explicitly cut out retailers. So I appreciate y'all's concern, so thanks.
Appreciate you bringing their attention. Yes, sir. Come forward, Todd. Give us your name and who you represent.
Thank you, Mr. Chairman. I'm Todd Edwards with the Association of County Commissioners of Georgia. We've worked over the interim with several groups, the author, prosecuting attorneys. We fully support the bill in its current form. I would note from the testimony earlier that the reason this bill is brought up is, and the reason I don't see there to be a problem and any mistake on the owner, is if whoever provides the dog simply turns them over or relinquishes custody, then none of this process, you don't go through none of this process. It's only at the point where the owner doesn't relinquish, or the perceived owner, as was stated earlier, does not relinquish custody, that the bond is charged or established through the court and all the safeguards that have been put in the bill. So if there were a problem there, you simply just don't claim ownership to the animal, and none of this ever takes place. We do support the bill and ask your favorable consideration.
All right. Thank you. Any questions of the committee of Mr. Edwards? Appreciate you coming before us today. Do we have anyone else who would like to address the committee on Senate Bill 356? If not, we will close off further public comment. The bill is now in the breast of the committee, and the chair will take motions on the bill, which is SB 356 FA1. Do we have a motion? Motion is due pass, and it has a second. Any discussion on the motion? Any amendments? Chair hearing none, the chair will call the main question, which is due pass Senate Bill 356. All in favor signify by saying aye. Opposed, like sign. Motion carries. Thank you, Senator.
Thank you.
Glad to have you with us. We'll go back to our list, and I believe Senate Bill 183 will be the next bill. Senator Wilkinson, come forward. Anyone else you want to have with you? All right. I'm trying to find my copy of it, Senator. I don't seem to have a copy of my file for some reason. We have Senate Bill 183, which is LC 297088 ERS. And Senator, will let you state your bill.
Thank you, Mr. Chairman, members of the committee. At the present time, Georgia law provides liability relief for equine and llama owners if they post a sign on their property signaling the inherent risk associated with these animals. We would like to extend this law to include cows, sheep, pigs, and goats. So that's basically what Senate Bill 183 does, and I'll be glad to answer any questions.
Whose subcommittee was this? Yours? Tell us what happened, Judge, in the subcommittee on the bill.
We had a subcommittee hearing, Mr. Chairman.
Let me get you the mic on now. Sorry, just hit your button. I know which one it is. I think it's number 14. Yes, sir.
We had a subcommittee hearing on this 2 days ago, and in that subcommittee hearing, we offered some amendments. There were 4 amendments that were offered by Chairman Welch. They were accepted by the committee and then passed on to the full committee.
All right. Tell us about the context of the amendments, what they were doing,
Let me get to where
if you recall. I mean, I was there, but I just wanted to get you as the chair, if you could, to bring us up to date on it.
Remember exactly what it was, Mr. Chairman. We took out some wording.
I think the basis of it was to recognize, as the senator was talking about the liability issue, that there would not be where you have a cost incurred for someone going on to property or to have access to the animals, et cetera. The waiver of liability,
There
because
was a provision that had to do for profit was taken out.
That's
If
right.
they were charging a fee or had it in for profit, those were amended and taken out.
Okay.
Those were the changes.
Right. Okay, over here we have Ms. Evans. You wave, okay. And next we have,
I was just
Mr.
adding.
Bennett?
I was waving to, just adding input on what we
you're always waving at him, okay. No other questions? All right, would you like to address us, Ms. Quick?
I would, Mr. Chairman, if I could, and I actually brought a case that's made it around this side of the table, and if I could make it around to the rest of the table. As Senator Wilkinson has said, the original intent of the bill was simply to include livestock activities in an existing statutory framework which limits civil liability for injuries which may arise as a result of what are the inherent risks in interactions with animals, which can be unpredictable and somewhat dangerous. So the current law protects equine and llama activities, and the bill would seek to provide corresponding protection for activities associated with swine, cattle, sheep, or goats. And so that was the original intent of the bill. And with all due respect to the subcommittee and the substitute, as we say in the House sometimes, the bill has now been grooverized from the perspective of the industry, because the original statutory framework in applying to equine was enacted in 1991 and expanded upon and described in the case of Mueller versus English in 1996. And so this bill has been providing protection for an industry which is in whole and in part a profit-based industry. So the effect of the amendments is to take away the existing immunity for the equine industry and the llama activities and the llama industry. And so where this situation arises is we have industry producers in the agriculture arena who have people on their premises and have access to animals incidental to the fact that they make money, some degree of money, on these livestock activities. And so in eliminating the profit component of this, it not only substantially changes the existing law, but really doesn't accomplish what the industry wants to accomplish, with all due respect. So the case that I've handed out is Taylor versus Howren, and that's a 2004 case, and that explains the structure. There's a series of cases through and including 2014 that explains how this framework operates in terms of the livestock liability features of this, and that in certain circumstances there will be liability, in certain circumstances there will not. It simply is a codification of assumption of risk, if you will, if the owner of the livestock, of the animal, posts a sign, provides adequate notice for folks to understand the inherent risks of the animal. And so, Mr. Chairman, that's my legal commentary on the difference between the subcommittee substitute and the original bill as passed the Senate.
Okay, can I make a comment?
Yes, sir. Senator, please.
A couple of things. First of all, I really appreciate Representative Quick's assistance with this. She's been very valuable, and again, as I said the other day in the subcommittee, when I have to sit in the middle of this many lawyers, you know, that makes me a little apprehensive. But I'll make a couple of observations. You know, I've got the copy of two bills here. The one I've got is SB 183 FA1, and so for whatever it's worth, you know, I do like that one the best. But the one we're considering right now is LC 297088 ERS, and so with my limited legal knowledge, I would agree with Representative Quick's assessment, but I'd be real proud if I could get that one passed today.
Yes. Okay. Well, we're maybe inclined to that. I think the thing we ran into, Senator, was we recognize there's a desire and a well-needed plan for children to have access to farm animals as a part of their 4-H and other agriculture training. The thing we try to watch is having a farm open for that, as opposed to someone saying we're going to make charges for that. And so we're open to having the farms open and agriculture industry open to having places for them to do it. It's hard to draw a line. You know, are they charging just $1? I mean, we can't make the subjective determination of how much is a charge for just covering an incidental cost as opposed to the profit motive.
And what this would do with the bill in its current version, the way that I read it, I was at a meeting in Perry yesterday at lunch, and I had a cattle producer who said to me, you know, I'd really like to just invite students to come out to my farm just to look at the cattle and talk to them about them and those kind of things. And at the present time, he's hesitant to do that. But I think if we pass this today, it would give him the opportunity to do that.
Opportunity, both going through the requirements under the law with the signage and everything else. So he's fine in doing that. That will be a protection for him and a benefit. I think it would. Any other questions of the presenters? Is there anyone else who would like to address the committee on Senate Bill 183? If not, we'll close off further public comment, and the bill is now in the breast of the committee. The chair will entertain a motion. It's been moved to pass. Do we have a second? It's been seconded. Is there a discussion on the motion? There being none, are there any amendments? There being no amendments, the chair will call the main question, which is a pass to SB 183, which is LC 297088 ERS. All in favor signify by saying aye. Opposed, like sign. One nay. The chair's ruling is the motion carries. Thank you.
Thank you, Mr. Chairman.
Thank you,
Glad
Mr.
to have you with us,
Chairman.
Senator.
Yes, sir. Thank you.
Don't be afraid. Who's your sponsor? Oh, Ms. Quick is going to be. Representative Quick will be the sponsor. Keep reminding me. Don't give up on me. Next we have will be Senate Bill 206, which is Senator Ligon. There you are. This is another we've had a lot of discussions about. This is the water lien bill.
Yes, sir.
Glad to see you, Senator.
Good to see you, Mr. Chairman, and
Thank you.
members of the committee.
We're on Senate Bill 206, LC 297091 ERS.
Thank you, Mr. Chairman. There have been some issues in some of our cities throughout the state where individuals either leasing property or purchasing property have had difficulty ascertaining if there was a water lien, which is a lien of high priority, and then they've gone, after they've occupied the property, they go to have the water cut on, and they're told, well, you can't cut the water on until you pay this $1,000 or thousands of dollars to have the water cut on, or they may have difficulty getting a statement of the amount of the lien. And the bill addresses that problem. It provides a mechanism whereby a purchaser or an attorney or a lender or even a tenant could send a letter by certified mail, return receipt requested, a statutory overnight delivery, or if the supplier allows for electronic communication by email, requesting for a statement of the amount of the lien. The supplier then would have a period of 10 days in which to provide that response. They're authorized to charge a fee of $10 in order to help defray any out-of-pocket expenses that they may incur in providing this information that lets the person know the amount of any lien, or if there's no lien, that there is no lien. If the supplier fails to provide this information within that period of time, then the property is freed from the lien for the unpaid water bill. And then that statement is good for a period of 30 days. And we also have a provision here. We have some different situations with condominium associations, and we're not having this code section apply to the condominiums. And that is the essence of the bill, Mr. Chairman.
I'll go back historically. I know I've served with the State Bar's Advisory Committee on Legislation, and for the last, I believe, at least 2 years, this has been a matter of interest to the real estate section of the bar because of what we're talking about.
Yes,
lawyers are expected to sign off on title policies saying everything's free and clear, and then out of the blue comes a claim, and they had no way of knowing, first of all, because it's not a recorded document anywhere.
that's right.
And if the initial plan was to try and have them set up dockets.
Right.
And I know the local governments were very reluctant about trying to say we're going to maintain dockets.
Yes, sir.
So I think as an alternative approach, what we have here is a notice provision where there is a required notice sent that will be dated, timed,
Yes, sir.
and received, dated and timed, so that there's actual knowledge by documentation.
Right.
And that way, they've got a time frame in which to give you, or the closing attorney will call you, sufficient information so that you can prepare for the closing and know that when done, there is going to be a lien cleared up, or there's not going to be a lien on the property.
Yes, sir.
Simple as that.
That's correct.
Any questions of the presenter? Yes, ma'am, Ms. Jones.
Thank you, Mr. Chairman. So, just so I'm clear, if someone is purchasing this property and they do not request this information, then they become responsible completely for whatever lien is on the property that was incurred by the previous owner.
Okay. It depends on the nature of the property. If this is a residential property, then they could not have the water. They would not have to pay the bill in order to have the water cut on. But they could be responsible for the water. There could be a lien that attaches to the property, yes. So it's important to send out this request and determine whether or not.
And what if it's
there is a bill.
commercial?
Commercial, if it's commercial under current law, then the supplier is not under an obligation to cut the water on until the bill is paid. But under this bill, if the if the new owner or tenant sends the request, then they can determine if there's a lien, and they could buy the property or not buy the property or lease it. And if the city fails to respond, then that frees the property from the lien and from the obligation to pay the water bill.
So if I have a property that I lease out to someone, they have the water in their name, they run up a massive bill, they skip town, I evict them, they stop paying me, and I want to put somebody else in that commercial property or sell it or whatever the case may be, I can't do so without paying for what the person who was in there before me ran up.
Right now, if you don't, as it stands right now, the supplier would not have to cut the water on unless the bill were paid. Now, the supplier could not lien the property because the person who incurred the bill was not the owner. Only an owner of property who uses the water can be liened.
Thank you. No further questions.
Thank you. Mr. Welch.
Yes, Mr.
Welcome.
Chairman. Thank you. Sorry for my tardiness. Chairman Maxwell kept me.
No problem.
So what I just heard you say, Senator, was that the person who owes the money can be liened. How is that possible?
Well, No, I said the owner of the property. If an owner incurs a water bill, then that property can be liened. There's a lien that's created. The law provides that when the bill is incurred, the lien arises. It does not have to be recorded. It's just there by operation of law.
But isn't there a contractual relationship between the tenant and the landlord in which the landlord is essentially taking on the risk that a tenant may or may not actually do what he or she should do under the law, and in engaging in that marketplace rental, shouldn't the landlord bear some responsibility for making good on the payments if the tenant does not, or at least allowing for the recourse to be between the landlord and the tenant, as opposed to just ignoring the tenant and allowing them to walk away because there's nothing to lien if the tenant leaves?
Well, that's a public policy decision, and right now, I mean, we've decided that you're not going to hold a landlord responsible for a tenant's debts. And actually, existing law, which is found on lines 56 through 58 of the bill, provides that a supplier cannot impose a lien against property unless the owner is the person who incurred the charges. That is existing law now, and it's been that way since, I think, 1994 when this law was first enacted.
Anything further, Mr. Welch?
No, not at this time.
All right. Yes, sir, Mr. Powell.
All right. Assume that the lien is extinguished for whatever reason, but the bill is unpaid. Can the supplier still, say for instance, the new owner of the property, can they still refuse to extend service even though they haven't got a lien anymore, but can they refuse to extend service because of the unpaid bill?
It is, I have, since our last hearing, I've learned that is actually happening, that even, for example, you have a tax sale, there's a foreclosure of the right to redeem, and maybe even a quiet title action is filed, and the city will say, well, we recognize that we don't have a lien, but we're still not cutting on the water. And I've heard that there's an amendment that would address that, and I'm certainly open to that. I don't think that if you read the reasoning in the case law that gives rise to this lien and gives it the high priority, I think that if the lien is extinguished, the right to withhold the water goes away as well.
But wouldn't it be worthwhile to clarify that?
We may have to clarify that. Otherwise, it's going to take a court decision to do it. And I haven't researched it, but just thinking about the case, I think that would be the case.
Because what it says, there's no lien.
That's
but
right.
But you still have an outstanding debt, and the supplier can go after the person who incurred that debt still for lawsuits or whatever to collect the money.
Right, but
just can't go against the property.
That's right. Well, and that's what they're doing. But when I read some of the cases that I've read, they discuss that the right to cut off the water is somehow tied to it being the existence of the lien. So I would think logically, if the lien goes away, then the right to cut the water off goes away as well. But that's not what's happening.
Thank you, sir. Any further questions of the presenter? If not, do we have anyone in the audience who'd like to address the committee on Senate Bill 206? There being none, all right, we will close all further public comment. The bill is now in the breast of the committee. The chair will entertain a motion. We have a motion to pass. Is there a second? It's been seconded. Any discussion on the motion? Any proposed amendments?
I have a proposed amendment if somebody will hand it out.
The House. Yeah. Who's going to be the House sponsor?
Representative Atwood.
Thank you. Somebody you know well.
I know well. That's right. Give him something to do before he leaves.
Before he leaves, that's right. One more bill.
One more bill. And he'll do a good job with
All right. We have handed out an amendment to Senate Bill 203 consisting of 4 lines. You want to read the amendment out loud, Representative Powell, Chairman Powell?
All right, at the end of line 58, where the period exists on charges, it would be deleted. And inserted would be, after the word charges, and shall not deny water surfaces where such a lien has been extinguished in an in-rem action or a conventional quiet title action in accordance with any non-judicial tax sale in accordance with Code Section 48-4-40.
Discussion on the amendment, please. Ms. Travis?
Yeah, well, I would just, a couple of changes would be, first of all, we amend the right bill, which is 70910ERS.
Yeah, you got the wrong number up there. That's right. Okay.
Change where to when, because we're talking about a time, not a place. The conventional quiet time is QUIATIME.
Quia title.
And
It's actually quia timid, isn't it?
Yeah. Mm-hmm.
That's it.
That's it. I was questioning why do we want to go all that part of this saying, and shall not deny water service where such a lien has been extinguished, period. Why do we need to have the other portions of it?
I don't know.
Mr. Walraven, your amendment, I believe, you want to speak to that? Because I had that question to you earlier. I mean, it just seemed like once you say the lien's extinguished, that clears up, and we're trying to limit to certain things happening before the lien is extinguished.
Yes, sir.
Thank you.
Excuse me, Mr. Chairman. Ladies and gentlemen of the committee, I'm John Walraven. I represent Investa Services. This is my client, Adam Caskey. He's here today. I would first like to thank all the folks at GMA, the realtors, and the Georgia State Bar for letting us work at such a late hour on this bill and try to perfect this amendment to protect and clean up some really rough blight, particularly in Atlanta, when it comes to the fact that in the situation where we have in-rem actions or conventional quiet title actions, there is no lien. There's just an outstanding bill. The lien is eviscerated once the foreclosure occurs, and in my discussions with the attorneys with GMA, they felt comfort in citing the 2 different ways to quiet title and specifying the tax sale.
Well, I just say if it's extinguished, it's gone. And now we're saying extinguished in certain forms. I don't know what other forms there may be.
I would agree with you.
Why not just say there's no longer a lien there? You can't stop providing water to that property because you don't have a lien.
I'm not going to disagree with the
He's
legal
right.
opinion.
He's right.
But I would defer to my colleagues in the hall from GMA to
Well, if they
speak
want to talk
would
about
like
it, I don't
to.
know what makes a difference, really.
Okay.
I mean, I agree with you, Mr. Chairman. If the lien has been extinguished, whether it's through
How
a
is that?
foreclosure or through a quiet title action or through a tax sale,
Yes.
and it's not the original owner who is now at the who's incurring the water, I say that it should cover all of those.
Okay. We'll try and address that then with the, you want to state your amendment that will be the one you're offering?
The one we're offering, Mr. Chairman, is and shall not deny water services when such a lien has been extinguished.
Period. Correct? Is there a second to the motion? It's been seconded. Any discussion on the motion? All in favor of the Powell motion signify by saying aye. Opposed, like sign. Motion carries. Are there any further amendments to be proposed? If there are no further amendments, the chair will call the main question, which is a due pass to LC 29-7091 ERS of Senate Bill 206 as amended by the Powell amendment. All in favor signify by saying aye. Opposed, like sign.
Aye.
Motion carries according to the ruling of the chair. Thank you.
Thank you, Mr. Chairman. Thank you, members of the committee.
And that'll be handled by Atwood.
Yes, sir.
All right. Okay. Lost my sheet here. Here we go. Is Senator Stone here? I can't. Didn't see him, but how about Kennedy? We'll go ahead and give you your second. I know you're ready. And you got some people here with you.
Yes, sir.
We'll bring them all up with you if you like, and
All right.
we'll have you in the middle maybe, and let them sit
Okay.
to the side of you.
Oh, sorry.
And if you will, we're dealing with Senate Bill 333, which is LC 410635. Senator Kennedy, why don't
Yes,
you
sir.
introduce your guest?
Good afternoon, Mr. Chairman and members of the committee. Thank you for allowing us to appear. I've got Matthew Kubion, who appeared 2 days ago before the subcommittee and described this bill. He worked closely with the bar, Mr. Chairman, on this, and would like to address the committee. Also have Mr. Kirby Thompson from SunTrust Bank, who may be here to answer any questions that the committee may have concerning the import of this.
Welcome.
Thank you.
Mr. Kubion.
Thank you, Mr. Chairman, members of the committee. Thank you for letting me be here today to present this bill, SB 333. This bill is designed to take advantage of some recent changes in IRS guidance that would allow nonprofit corporations to convert from out-of-state corporations to in-state Georgia nonprofit corporations and vice versa. We're creating the procedure for that to happen because under prior rules, nonprofit corporations had to merge into the state, and if they did so, they had to get a new letter of exemption letter from the IRS. And under these new rulings that the IRS has released, that would not be necessary in this type of procedure. So.
All right. Mr. Thompson?
Mr. Chairman, I'll just add that at SunTrust, we bank many nonprofits and many foundations. In the state of Georgia today, there are probably over 1,500 private foundations. We think there's probably over 22,000 nonprofits, and we believe that this is going to help create more opportunities for those to come to Georgia. Selfishly, I would tell you that the SunTrust Foundation itself now resides in the state of Virginia, and that's a $300-something million foundation, about $330 million, that if this statute passes, it would make it easier for us to move that back home to the state of Georgia, where SunTrust Bank has been for almost 125 years. So we fully support this bill.
Thank you. Let me ask this, Mr. Kubion. We're moving an entity that was created in another state to Georgia with the same charter, articles of incorporation, they would call them today. What if their articles of incorporation do not comport with what we have as far as legal requirements in Georgia for an articles of incorporation?
So if you look at line 33, this is subsection 14-3-1125, and in that subsection,
we're all missing page 2. It looks like. How'd that happen?
Well,
I know what happened. They did the. It was front and back, and we just got the fronts. Let me. Thank you. Thank you. What was that line number again, Mr.
so this is line number 33. This is
33.
subsection
Yes,
5.
okay.
So part of the certificate of conversion that has to be filed at the time to do that would require a statement that the articles of incorporation do comply with current Georgia law.
Okay.
Looking at subsection B in particular, and so a corporation who wanted to do that would either modify their articles prior to moving, or they would do it during that process.
Understood. Okay, so there's a mechanism to
Correct,
override that problem.
Correct.
Do y'all want to wait to get a full copy of the bill since we're only dealing with the odd pages right now, or do you have a desire? Anybody?
I do.
You do. we will have to suspend while we get the bill run, if I might. Sorry about that. Whoever ran the bill didn't include the front and back, so just to the front. Who will be your house sponsor, Senator Kennedy?
Yes, that's Representative Barry Fleming. I'm sorry.
Representative Fleming, all right. You getting them done?
I'll go check on it.
We got. How'd you get one? Other committee? There you go. There you go. Well, we gotta get one for everybody. Because we don't have them copyright. Did we find Senator Stone? I think he's got a fairly quick bill.
Last time I saw Mr. Chairman, he was invited.
Okay.
Matter of fact, presenting the bill.
Okay.
That was 2 o'clock.
full bill copied. And I think, do we have any questions of the presenters? Yes, sir. Mr. Welch.
Thank you, Mr. Chairman. I'm sorry, I've got multiple versions here, so I'm trying to. Can speaking to lines 75 through 77, the bill exempts the converting or foreign corporation from real estate transfer taxes to be provided when they record certificates of conversion. Why is that? Why would we exempt them since all other corporations would have to pay that otherwise?
So the reason for exempting them from real estate transfer taxes, there's no real estate transfer in this. This is a continuation of the entity as it existed before. It remains in the hands of what is the same corporation for corporate law purposes. So there has been no transfer. So we just wanted to be clear that because there is no transfer, no real estate transfer tax should apply. There's
Yes, sir.
That's further questions?
I might.
Okay.
Still catching up on those odd pages.
Okay.
Mr. Chairman, I don't have any further questions.
All right. Does any other member of the committee have any questions? If not, we appreciate it. Is there anyone else in the audience who would wish to address the committee on Senate Bill 333? There being none, the chair will close off further public comment, and the bill is now in the rest of the committee, and the chair will entertain a motion. Motion is due pass. Is there a second to the motion? Second. It's been seconded. Is there discussion on the motion? There being none, are there any proposed amendments? There being none, the chair will call the main question, which is a due pass to Senate Bill 333, LC 41063S, 35, All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you, gentlemen. We appreciate your coming today and being with us. And you're going to have the bill carried by Representative Fleming, is it?
Yes, sir. Yes, Mr. Chairman. Thank you, Mr. Chairman, to you for the courtesies and allowing us to appear and to the committee members. Thank you.
Happy to
Thank you very much.
I was texting Senator Stone, but I haven't received a response yet, so I don't think he's going to be able to make it in time. That's the last remaining bill that we have is SB 269. What we'll do is we'll carry that bill over to the next meeting, which will possibly occur on Monday or Tuesday. And Judge Lane, always a joy to see your happy face here with us.
It's a joy to be here with you. I miss sitting up there a lot.
Mr. Chairman, Senator Stone's on the way.
He is on his way? Okay. Well, let's hold up. He was coming. I want to try and get him the courtesy of getting his bill before us. No, sir, we're going to. He just said Senator Stone is on his way, so we'll wait a minute. By that courtesy. We're on then Senate Bill 269, and Senator Stone, this is LC 296901S SCS.
Right.
And if you'd like to present that to us?
I would. Thank you. This is the same bill that was taken up in subcommittee yesterday. What it does is close what we consider a loophole, or tightens up, whichever description fits best. Georgia's anti-sanctuary city law. In Georgia, Georgia has already enacted a statutory policy forbidding cities, counties, and other local governments from refusing to cooperate with federal immigration authorities. Around the country, the reason we have that in the law is around the country there have been local governments who have not cooperated and have in effect become sanctuaries for illegal immigration. Georgia, of course, has taken a position against that. The problem in Georgia's law, even though it potentially could deny funding from state agencies to violators of this policy, it did not require affirmative reporting of compliance. It was permissive, left to agencies to determine whether they wanted it reported or not. What this bill does is require certification annually by local governments as a part of a report that they're already required to make, and that's the immigration compliance report. It's done with the Department of Community Affairs. This was a change from the original language, which simply required reporting but didn't say where. This was done in consultation with the Georgia Municipal Association and ACCG. With that, I'll be happy to answer any questions from the committee.
Do we have questions? Yes, Ms. Oliver?
I think I understood this yesterday, and I wanted to double check that I'm correct. This dispute about whether a city is labeled, and there's no legal definition, whether they're labeled a sanctuary city or not, has to do only with the financial dispute that's going on between the federal ICE group and the local county on the cost of housing deportees. Is that correct, sir?
Well, not exactly. That may be why an individual jurisdiction might choose to allow itself to violate Georgia's anti-sanctuary policy. But this bill does not get into that. This bill just requires annual certification that you're complying with Georgia law.
And the practicality of that, this is what I want to understand, because they're already against the law. They're having a standoff over what the federal government should pay the local government. That's what I understand.
That's one instance of non-cooperation.
And what are other examples of non-cooperation other than that financial dispute?
I can't give you an example, a list of examples, but that is one that comes up frequently.
That's the one I've heard about.
Right.
So the practical consideration of this bill, since they're already not in compliance with something, is that they have to certify that they're complying with the law, and that's the requirement of the bill.
Right.
And the impact of that would be to, arguably from your perspective, take away that leverage to negotiate with the feds over the payment. Is that the practical result of that?
Well, there should not be any reason for local governments to refuse to comply with state law that's in that.
In your view, which is I'm very respectful of, they shouldn't be using that leverage.
They should.
Okay. And from my perspective, that's a risk they're taking based on whatever dollar dispute they're having.
And they're just hoping that they don't get caught.
And
that's happening.
And I wonder if that leverage strategy is working anywhere. I just don't know.
I don't know, but it's not something we need to promote.
I know DeKalb County Jail at some point was contracting, or this is why I'm interested in using, because we have the biggest jail on the planet, I think, and they were contracting with the federal government on a variety of different federal bodies for fee, and that's a constant tension. And I think they stopped taking federal deportees, if I remember correctly, based on this dispute. That's why I'm interested. It's a money dispute, leverage trying to be held, cities, counties taking risks. Maybe somebody can confirm that.
All right. Further questions, members of the committee?
Senator Stone, I apologize. I was in your committee waiting on you to come to get a quorum. That's why I wasn't here. But fine.
I was in the House Banking Committee.
Yeah, absolutely. That's the way it works. The issue as it involves local governments, and I apologize if I'm rehashing some area that has already been talked about, but the issue that we're, I think, attempting to prevent in Georgia are things that are happening in other parts of the country. Is that not right?
Oh, absolutely. I've got a little map here that I bought yesterday that shows how widespread it is. Don't have it handy, but it's all over, and unless we make it clear that that's the law in Georgia, it's coming into Georgia as well.
Also, I mean, this is the case that I heard about where the young lady in California was killed. If I'm not mistaken, I think it was at San Francisco, where the young lady was. There was a police department that refused to cooperate with ICE on notifying them of someone they had in their custody. The fellow ended up being released. He ended up murdering a young lady. That made a lot of attention nationally. Is that what I remember?
Well, that hit the headlines, but it's more widespread than that. And San Francisco is unabashedly a sanctuary city.
Okay. Thank you, Mr. Chairman.
Further questions of members of the committee? Yes, ma'am.
I think I asked you this yesterday. There are no sanctuary cities in Georgia at this point.
Maybe sanctuary counties, but not cities.
But not cities.
And it's just euphemistically called sanctuary cities.
And we know of 2 counties? Or
maybe 3.
Okay.
Yours, Fulton, and
Gwinnett, maybe?
I don't think it's Gwinnett, but it's in the metro area.
Don't you think the federal government should pay the rate that it costs the county to hold these people?
Right. I think they should pay as much as we can collect from them.
Right.
Representative Welch.
Yes, thank you, Mr. Chairman. So the certificate of compliance, could you just explain what 368023 is? I was trying to pull that up and look at it.
All right. That's section 1. Section 1 of the bill, that is 368023 is the provision that says
there's a lot more to it than that.
Right. Well, I understand, but the key provision is that under current law, as a condition of receiving funding through state agencies, the state agencies may require certification of compliance. And this just says it shall. As a condition of funding, they shall certify. And the section you first referred to on lines 49 and 50 on page 2, that is one of the things that is included in the immigration compliance report. So that's added to that report that they're already required to make.
Okay. No, that's it. Thank you.
And one other thing, Representative Welch, I believe the definition of sanctuary policy is also, I believe, included in section 3680.
Yes, sir. Okay, thank you.
Is that all?
That's all.
Mr. Fleming.
Mr. Chairman, Senator Stone, Representative Welch touched on something that I wanted to ask you about, and this came up earlier, as I recall. I had a situation where one of the municipalities in my district applied for some sort of grant with DCA, and they were denied that grant because of some violation that had occurred in some use of DCA money 25 years early. It ended up being a mistake, and they got it corrected, and on their next application they had enough points. Is that what we're talking about here? The ability for local governments to, from the state of Georgia, to get various kinds of grants and help from the state?
That's already the law.
And there's in the form that we're talking about, it's already a form, and if I'm not mistaken, there's numerous things on there they have to check off that they're in compliance with, and this would be one more check on that list. Is that right?
Additional box to check.
All right. And so now, if a local government does not comply with this or anything else like the example that I gave, there's not anybody there to go and revoke their charter or enjoin their commission from proceeding. It simply disqualifies them for certain types of state involvement from the.
Right.
Okay.
And there's nothing in here that prevents amending, if you're out of compliance with your forms.
Right. Right. Okay. Thank you, sir.
We talked a little bit about this the other day. What happens, though, if you have the filings by the local governments, which is, you say, mandated, but if they don't make a filing, they don't make the reporting, is there a mechanism that says they have to do it, and if they don't do it, there's some kind of penalty, or do you know?
As a former mayor, we're very mindful of those letters you get from DCA that say you need to do something, or you might lose your ability to apply for grants.
Okay. And those grants come not only from DCA but from other departments?
From other, you could have
road grants or?
Road grants, LMIG. This deals with federal grants administered through state agencies. Yeah. Right.
Chair's going to
certainly. Are you having to have a split personality, be in two places at one time?
We were under consideration with Senate Bill. Please, attention please. Senate Bill 269 of Senator Stone. I took a brief recess. We're back in meeting. And is there anyone else who'd like to speak on Senate Bill 269? Yes, sir. Please come forward. Please, yes, sir.
Chairman Willard, thank you so much for taking me here. I left a lot of you.
Give us your name and who you represent.
Everett Howe, and I'm here as a concerned citizen.
All right, sir.
And this is for you, Senator Stone. I did talk to Senator Stone, what, 5 or 6 years ago. We had a nice conversation about the original anti-sanctuary bill.
Yes, sir.
I was very much against it, just because sanctuary sounds like church. There really wasn't too much in it, but I thought it would be a stepping stone for something in the future, and here it is.
Okay.
And I guess the questions, well, I gave you my religious views. Just so happened that all the readings in the Catholic churches in the United States today is about overstepping rule of law, whether it be the Jewish people, the Jewish clerics when Jesus was around, and then not following God's law of loving God and loving your neighbor. And I think this is a bad example of not loving your neighbor. But it's also, there's some functional things I think we ought to talk about, and maybe I missed it somewhere, but you know, the anti-sanctuary bill before was pretty clean, and we also have the IERB, the Immigration Enforcement Review Board. So I have a hard time figuring out why we're going to use a hammer to get everybody in the state of Georgia to make these reports when the IERB could just specify a certain county or city or whatever to fill out a report. You know, this sounds extremely complex and costly to me. Second of all, about Francisco. I can't remember his full name in San Francisco. He was actually released from federal prison and delivered to San Francisco Sheriff Department and asked them to proceed with a enforcement of a 12-year-old arrest warrant for marijuana possession. What they should have done, this is federal government, should have turned them over to deportation and ICE. They are the ones that messed up. It wasn't the San Francisco Sheriff Department. I can't remember if the trial has been completed yet, but he claimed it was an accident. He found that it's a park ranger's gun. It wasn't a gun that he had. He found it under a bench. And so, you know, this is, again, another story that got magnified. In fact, Congress tried to pass an anti-sanctuary bill and failed. Now, I'm hoping you can do the same thing. I think this is very sad. It's using a hammer to do something that could be done in a less costly way. So I implore you to vote against this in the committee, and if it passes in the committee, please vote against it in the House.
Thank you, sir. Any questions of the gentleman? If they're not, I think I see our local government representatives rising. If y'all want to come forward, we'll let you step back and let them have a seat. Thought y'all were going to stay quiet, but apparently not. Okay.
We'll
Give
be
your
quick,
name and who
Mr.
you
Chairman.
represent.
Rushi Patel with the Georgia Municipal Association.
Todd Edwards, ACCG.
And we just wanted to thank Chairman Stone and Ms. Travis for working with us on this language. We were just trying to ensure that any reporting requirement would follow the current reporting requirement in state law, and they were able to help us with that.
Good.
And we are okay with this bill, and so we just want to let y'all know we're good.
Yeah, it basically, we were already doing a report annually rather than reinvent the wheel.
Yes, sir.
This is part of the same process. It's good, efficient government, and I appreciate it.
Thank
Very
you.
good. Mr. Welch, you wanted to ask a question?
Just a question real quick. ACCG is fine with adding this to the reporting requirements for counties?
We're neutral on this bill, Mr. Welch.
Thank you. Any further questions? There being none, does anyone else desire to address the committee on the bill? If not, we will close off further public comment, and Senate Bill 269 is in the rest of the committee. The chair will entertain a motion. We've got a motion, do pass. Is there a second? There's a second. Any discussion on the bill? There being none, the chair, any proposed amendments? There being none, the chair will call the main question, which is a do pass Senate Bill 269 is LC 296901SCS. All in favor signify by saying aye. Opposed, like sign. Chair is in doubt. The chair will call for hands to show in support of the bill. All in favor of the bill, raise your right hand. 2, 5, 6, 7. Chair counts 7. All opposed, raise your hand. 1, 2, 3, 4, 5, 6. 7 to 6. The motion passes. Thank you.
Thank you.
Thank you, Senator. And who's your sponsor?
Representative
Petrie. Okay, we'll appreciate that. If there's nothing further to come before the committee today, we'll stand adjourned. Thank you.